welcome to SEO Explains. My name is Devjani and today we are going to talk about a habeas corpus plea concerning 5 missing Rohingyas which led to concerns about the safeguards owed to non-citizens. On December 2nd, 2025, a bench of Chief Justice Surya Kant and Joymalo Bagchi heard a habeas corpus petition which alleged the disappearance of a family of 5 Rohingya persons. The petitioner, Rita Manchanda, an academic and an activist, claimed through her counsel Ujjaini Chatterjee that the opacity in the removal process of Rohingya persons risked the possibility of unlawful transfer or trafficking. She relied on an office memorandum dated 2nd May 2025 which prescribes the verification of nationality, coordination with the country of origin and documentation at each stage of removal and public disclosure of deportations on an official portal. The petition states that 5 members were taken into police custody for collecting their biometric details. They were detained overnight and taken to the Indralok detention center in the capital. They were then shifted to an undisclosed location. Manchanda undertook an independent fact-finding mission and approached the Delhi High Court, where the Union government submitted a status report stating that the 5 members were a part of a group of 40 illegal immigrants identified as Rohingyas, who were escorted by the Delhi police to a designated destination for repatriation to Myanmar. The report is silent on how the authorities chose them out of the current 40,000 Rohingya population in India as estimated by the Human Rights Watch. The High Court granted liberty to Manchanda to withdraw her petition and approach the Supreme Court as a case raising concerns about the status of Rohingyas was already pending there. At the Supreme Court, Manchanda clarified that she does not oppose deportation as a matter of sovereign policy. The challenge is confined to whether it adhered to the procedure established by law. In a 2021 case titled Muhammad Salimullah vs. Union of India, a 3-judge bench of the court had declined to stay deportation of Rohingya detainees, but emphasized that deportation must follow a prescribed process. Manchanda does not challenge this outcome, but cites it in her favor. She contended that removals unsupported by documentation raise serious concerns of violation of Article 21 and risk converting deportation into extra-procedural expulsion. During the hearing, CJI Surya Kant observed that India cannot lay a red carpet for intruders and that we ought to focus on the poor among the Indian citizens who lack certain privileges, benefits and amenities. At the same time, he defended the right of illegal migrants not to be subjected to custodial violence. This prompted a public letter which alleged that the remarks dehumanized the Rohingyas. A counter letter cautioned against treating oral observation in court as determinations. The CJI has, however, sought to dispel misgivings that he might have breached propriety while hearing the Rohingyas case. The question of the refugee status for Rohingyas, their deportation on the ground of illegal entry into India, their repatriation to Myanmar and Bangladesh are distinct and separate from Manchanda's concerns. Yet, the debate triggered by the CJI's remarks has intertwined these issues, conflating her limited pleas for transparency with the broader refugee question. Read our analysis on this issue by V. Venkatesan on our website. For more such stories from the Supreme Court, follow scobserver.in. Thank you for watching.